Today's Brandon's blog is the Canadian Motor Freight Ltd. Sad Receivership Saga, our complete guide on what happens when you don't follow court orders. It is very unusual in a court-supervised insolvency proceeding for people or companies to be held in contempt of court. The court bends over backwards to allow the person or people to purge or eliminate their contempt, to do what the court has directed, to finally do it. But in this receivership case, everyone dug in, and rather than performing the way the court directed them to, they appealed the decision to the Court of Appeal for Ontario. And the Court of Appeal dismissed the appeal, finding no error in the lower court's finding of contempt. And fines had to be paid, and people actually went to jail, albeit for a short time period, just 4 days, but they were still in jail for not following the court's direction. So in this Brandon's blog, Brandon goes through the history of the receivership, what led to the contempt finding, and all the goings-on that the people did to try to frustrate the efforts and block the receiver from being able to do its job. My name is Ira Smith, president of Ira Smith Trustee and Receiver, Inc. Both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So if you or your company have too much debt and you just cannot find a solution to your financial problems, shoot us a message, give us a phone call. We would love to speak with you.
Have you ever wondered what happens when a company can't pay its debts and then decides to ignore the law? The story of Canadian Motor Freight Ltd., a logistics company based in Mississauga, Ontario, provides a stark lesson in exactly that. This is a tale of financial crisis, missing trucks, and a serious showdown with the Canadian legal system. By October 2024, Canadian Motor Freight Ltd. was in deep financial trouble, owing over $20 million to Canadian Western Bank, CWB, and struggling to keep up with payments. This led to a legal process called receivership, where a licensed professional is appointed by the court to take control of a company's assets to pay back creditors. The court moved quickly, placing Canadian Motor Freight Ltd. into interim receivership on October 8, 2024, and then full receivership on November 15, 2024. This decision wasn't taken lightly. The company had stopped making loan payments, given false financial information to the bank, and was consistently losing money. They also owed around $1.7 million to equipment financing companies, and were secretly selling their accounts receivable. Adding to their woes, the city of Mississauga had even started tax sale proceedings for unpaid property taxes. The court appointed a receiver to take control of all the company's assets and manage them fairly to repay their debts. One of Canadian Motor Freight Ltd.'s most valuable assets was its fleet of trucks. These vehicles were crucial for paying back some of the $20 million owed. However, instead of cooperating with the receiver as the law required, the company's management made a critical error. They moved all the trucks to a yard owned by another company called United Group of Companies. This action directly violated the court's receivership order. They continued operating as if nothing had changed, missing deadlines for financial disclosures and failing to attend mandatory court appearances. This wasn't just negligence, that was a direct violation of legal requirements. When the receiver discovered the trucks were missing, they tried to communicate with United Group to get access to them. When these discussions failed, the receiver had to go back to court to obtain a specific asset recovery order, legally directing United Group to allow the receiver onto their property to take possession of the trucks. Unfortunately, this new court order was also ignored. United Group and its management refused to comply and wouldn't let the receiver take the trucks as instructed by the court. This direct defiance of a court order is a very serious matter in the Canadian legal system. Because both Canadian Motor Freight Ltd.'s management and United Group weren't following the court's instructions, the receiver took further legal action, asking the court to hold both companies and their management in contempt of court. The evidence revealed a clear pattern of defiance. The debtor company deliberately moved the trucks, United Group refused access, demanded unauthorized payments, and even secretly moved the trucks again after being ordered to provide access. The judge strongly criticized these actions, calling it a shell game, and saying they were thumbing their nose at the court, which undermines the entire legal system. The judge found both Canadian Motor Freight Ltd.'s management and United Group's management guilty of civil contempt. In Canada, 3 key elements must be proven for civil contempt: the court orders must be clear, the accused must have known about them, and the violation must have been intentional. The judge found all 3 conditions were met, dismissing United Group's claim of mere negotiation as a delay tactic. The leader of United Group was even sentenced to 4 days in jail, and both United Group and other individuals involved were ordered to pay significant financial penalties to cover legal costs. Unsurprisingly, both Canadian Motor Freight Ltd. And United Group appealed to the Court of Appeal for Ontario. However, on April 8, 2025, the Court of Appeal dismissed both appeals, fully supporting the original judge's findings. The Court of Appeal firmly stated that court orders are not to be stalled, and they are not to be negotiated. Serious consequences are to be expected by anyone who willfully fails to obey a court order. The case highlights the critical importance of respecting court orders in Canada. Ignoring them can lead to severe legal consequences, including financial penalties and even imprisonment. It also demonstrates that transparency with creditors is essential, and that seeking expert legal and financial advice early when facing financial distress can help avoid more serious issues. The financial difficulties faced by Canadian Motor Freight Ltd., including rising costs and thin profit margins in the trucking industry, serve as a reminder of the pressures many businesses face. Ultimately, this case underscores that the legal system relies on the obedience of its orders to ensure fair resolution of disputes. I've helped numerous businesses navigate similar challenges successfully. The key is addressing these issues early and properly. When you work with a licensed insolvency trustee, you gain access to legal protections and professional expertise that can help restructure your debt and keep your business operating. We understand the complex legal and financial landscape and can guide you through various options, including corporate proposals, restructuring plans, creditor negotiations, legal protection strategies. The story of Canadian Motor Freight serves as a powerful reminder that ignoring legal obligations never makes them go away, it only makes things worse. At Ira Smith Trustee and Receiver Incorporated, we've seen too many businesses fall into this trap, and we're here to help you avoid the same fate. If you're feeling overwhelmed by business debt, don't wait until it's too late. We offer a free, confidential initial consultation where we can discuss your situation and explore your options. Remember, seeking help isn't a sign of failure, it's often the first step toward a successful turnaround. Let's work together to protect your business and find a solution that works for you. Thank you for watching, and we look forward to helping you navigate your business challenges.